Africa's Protection of Personal Information Act, better known as POPIA or the POPI Act, commenced on 1 July last year. And many organizations are now scrambling to get to grips with what this means for their business activities, their handling of information, and how to go about complying with this law. Joining us today to shed some light on these questions is Associate for VDT Attorneys, Commercial Law and Tax Department, Hayley Levey. Hayley, welcome to Farm TV this morning.
Thank you very much for having me, Lisa.
What is this Protection of Personal Information Act, or POPIA as it's commonly known?
All right, so the Protection of Personal Information Act, better known as the POPI Act, is in essence an act that seeks to protect the right to privacy as enshrined in our Constitution. And how it does this is that it places specific obligations on persons who otherwise request, collect, use or process information relating to other persons in order to protect such persons from harm. Furthermore, it establishes penalties in the case of non-compliance. It is established and very similar to the EU data protection law, better known as the General Data Protection Legislation, and is largely similar to the principles as set out therein. So many listeners who might have an organization that operates a global footprint might be acquainted to GDPR and can rest assured that POPI is largely similar to that piece of law, although there might be some differences.
So what do I need to know, or why do I need to be concerned with applying to this act?
All right, I think the question largely relates to if you should be able to comply with the Act, or do you have to comply with the Act? And in essence, what it boils down to, the general rule is that if you process information in South Africa, you are going to have to comply. What this essentially means is that if you have a business that is located in South Africa, or you have a person who is processing information on your behalf in South Africa, you are going to have to comply. In essence, that means complying with the 8 conditions for lawful processing. Now, if you are a farming business, or if you fall within the agricultural sector, you might be finding, well, this is red tape and I don't want to have to comply. At the end of the day, if you process information of other persons, whether it be your employees or customers, you will have to comply with the provisions.
So who does this act protect?
In essence, it protects both natural persons as well as juristic persons. In the first instance, what we mean by natural persons is living human beings. But by and large, also what many people don't realize is that it protects juristic persons as well, such as companies and legal entities such as partnerships or close corporations or trusts. This is quite radical in terms of our legislator, because they, unlike the GDPR, decided to protect juristic persons, whereas the GDPR only protects individuals. So organizations not only have to comply with the Act, but they can also gain protection from its provisions in the case of persons using information about them in the wrong.
Has POPIA commenced?
POPIA has actually commenced. So it commenced on 1 July 2020, and what many people might not know is that we're in the midst of a 12-month grace period. And what this essentially means is that this is afforded to persons to get their ducks in a row. So come 1st of July 2021, its provisions will be fully effective, and as well as its penalties. Now bear in mind that this is not a long period to get your ducks in a row, and that you will want to take the steps necessary to reasonably comply with the Act as soon as possible.
Well, don't go away, stay with us. We are discussing the POPIA Act, and when we come back, we'll talk about penalties. Stay with us. Welcome back. We are discussing the South Africa's Protection of Personal Information Act, which is also known as the POPIA Act. And with me is Hayley Levey. Hayley, what are the penalties for non-compliance?
All right, so POPIA essentially establishes a 2-stage penalties threshold. In other words, there are fines as well as imprisonment. The maximum fine that can be imposed is 10 million rand, with a maximum penalty in terms of imprisonment being 10 years. This could also be both. Now, bear in mind that given the severity of the non-compliance, that will largely determine what the penalty will be. However, please also bear in mind that notwithstanding these statutory penalties, the very devastating reputational damage that your organization can suffer, as we've seen in previous months, can largely destroy your organization if you choose not to comply or have mistakes creep in. And then over and above that, nothing precludes any interested person, whether it is the person to whom the information relates, better known as the data subject, or the person who actually is tasked with protecting the information, from approaching a court of law to seek relief and actually claim damages.
Who are the role players?
All right, so POPIA actually establishes many role players. We're going to touch on 3 today. And what's really important here is to bear in mind that given the scenario of processing and your organization, you might wear multiple hats, and therefore you need to actually zoom into the processing activity to find out what hat you're wearing in the circumstances and what role you're playing. So the first person is the data subject. This is, for instance, a customer, a person whose personal information is being processed. So in the context of an example, a business requests that information from the person in order to provide them goods or services. Practically speaking, this could be a farming business who requests information from a customer, who will be the data subject, or an employee in order to process their information in line with their employment contract. The second person is the responsible party. This is ultimately the person who takes accountability of how information must be processed in accordance with POPIA's 8 conditions. This, in the context of our example, would be the farming business who requests information, and they are then accountable to the regulator, who is POPIA's supervisory authority, as well as the data subject, to ensure that any information that is processed is in line, and they will bear the brunt in the case of something going wrong. The third person is better known as the operator. Now think of it as an IT service provider or a service level provider or a vendor, where, for instance, the strict definition is to say this is a person who is contracted in writing on behalf of the responsible party to assist them with the processing of personal data. In other words, they are not accountable to the data subject of the information regulator, but they are tasked in terms of that written mandate. This is really important to understand because it's not them who will take responsibility. They do not share responsibility with the responsible party. In other words, if something goes wrong, the right of recourse that the responsible party may have lies within that written agreement, that service level agreement, or the operator agreement that can be incorporated into that service level agreement at the end of the day. So therefore, if we had to look at the overall supply chain from produce of a farmer all the way up to a retail company to the actual customer, you can see that you could play different role players, and in terms of who you report to, you might be the responsible party, you might be the data subject, you might be the operator. And it's really important to understand what rights, responsibilities and powers you may have in the circumstances in order to effectively roll out what you need to comply.
So within an organization, who takes responsibility for POPIA compliance?
All right, so this is actually quite something that many people are not aware of. The leader or the captain of the ship being the responsible party, is actually a person who is assigned leadership within there, and that person is called the information officer. Now, the information officer has statutory duties and responsibilities to actually guide the responsible party in complying with the Act. They will be tasked with ensuring that that responsible party rolls out a privacy project that in essence is catered for how they process information on the day and ensuring that they meet their obligations. Now, interestingly enough, the information officer is a person that is appointed by default automatically in terms of POPIA, as well as its sister's piece of legislation, PIA, which we won't go into detail today. In the event of a formal appointment not being made, this person is the head of the private or public body. In other words, your CEO. You want to make sure that the person that is appointed or delegated authority, if it's not your CEO, is the right person for the job within your organization. They are going to drive compliance in terms of their delegation, and if they need assistance, because obviously no man is an island, they can have henchmen such as deputy information officers. Very interestingly is that in terms of the draft guidelines that were established last year in July, the information officer is required to be registered with the regulator's office by the 31st of March. Now, those guidelines have not been finalized as yet, and we await further clarification. But importantly, in terms of the most recent notice in February this year, the information officer's responsibilities kick in effectively from the 1st of May. And therefore, you want to ensure that that appointment is finalized as soon as possible because they are going to drive your compliance project.
Just in closing, Hayley, do you have any advice?
All right. In a nutshell, what's important to realize is that any compliance project requires consideration from an holistic approach, both from a legal perspective of how your company is processing data, as well as its technical systems. At the end of the day, it's a team sport. You need executive sponsorship, and creating awareness amongst your employees is very important because it's going to eliminate that human risk. Understand and appoint an information officer to drive the project, and seek outside help. There is a plethora of professionals out there that can help you drive your compliance project within reason and what is suited to your business. You do not want to reinvent the wheel because you did not get into your business to comply with red tape. So understand the landscape and go from there. We are less than 4 months away from the effective date, and therefore act now better than later.
Hayley, thank you very much, and remember the D-Day is 1 July, so get your necessary people appointed, and for any help, of course, there are legal professionals out there to help you with the South African Protection of Personal Information Act.